Okay, folks, let's get started. In this video topic, I'll talk about a foundational requirement of the criminal law. It's the requirement that the defendant must act voluntarily, or the act requirement. This basic requirement leads to a corollary doctrine, and that is there are no status crimes. Just as we've seen earlier, there are no thought crimes. There are no crimes based on a person's status, what the person is, rather than what the person does. And then finally, we're going to explore an exceptional setting when we ignore the act requirement and we do punish someone for a crime based on their omission or their failure to act. So let's jump in. As Blackstone put it, if you're going to have a crime, you've got to combine an actus reas and a mens rea, or you've got to combine the conduct with the blameworthy or culpable state of mind. Normally, you get this explicitly in the criminal code itself through the elements of the offense. And as long as the prosecution is proving all those elements, both the objective elements and the accompanying culpability elements, then you've satisfied the voluntary act requirement. Sometimes a specific crime doesn't explicitly say that you have to have an act. In that setting, some jurisdictions handle this by judicial interpretation. They say that the judges who are interpreting the statutes say that we will read this statutory element as if it required some kind of voluntary act. In other settings, the code will have a general statute in the general part of the code that requires a voluntary act, much as you have in Model Penal Code Section 2.01 Subpart 1. Here is a famous, a canonical example of a court interpreting a statute with some ambiguous language to require proof of an act. Cephus Martin is at home. He's really, really drunk. The police arrive. We don't know why. Perhaps he was shouting out the window, or who knows why, but they arrive. They forcibly take him out of his home and out into the public streets. And once he's there, he is engaged in, what shall we call it, indecent conduct. He's shouting, he's engaged in profane discourse, and so he's charged under Section 120 of the Alabama Code that covers this kind of conduct in public. And his defense is, hey, wait a minute here, I didn't do anything to appear in public. You hauled me out into the public, but that wasn't my voluntary act. And the court agrees and says, we read this statute, this appearance required in the statute, to require some voluntary act on the part of the defendant. You have to go into public and not be dragged into public. And for that reason, the court overturns the conviction. The court treats this involuntary appearance in public just as it would any other involuntary act. So you have cases of sleepwalkers who can't be charged under the criminal law for their actions while sleepwalking, or somebody who's in the middle of an epileptic seizure and has bodily movements that are not the product of a voluntary decision for the brain to contract the muscles in the arm or whatever other body part. We also see these involuntary act cases where person A pushes person B into person C. Obviously, you can't charge person B with assault if they didn't make any choices about moving their body. They're just reacting to being pushed from some other person or some other force. Now, this idea that a crime requires a voluntary act has a corollary. We punish people for what they do, not for what they think, as we've seen, and not for what status they hold. So there are no thought crimes, there are no status crimes. We don't punish people for what they are, we punish them for what they do. There's a constitutional dimension to this common law idea that the state can't punish a status. You see it operating in the case Lawrence Robinson versus California, a 1962 case. Here, a California statute makes it a crime to be, quote, addicted to the use of narcotics. And the police find Robinson in Los Angeles. He had been out of state, but he's here in Los Angeles now. They notice some track marks on his arm. That's their evidence to prove that he is addicted to narcotics. And he also admits to occasional use of narcotics, although not on any specific occasions, and possibly not in the state of California. He's convicted after a jury trial of being addicted. But the Supreme Court, by Justice Potter Stewart, pictured here, strikes down the statute that makes it a crime to be addicted because the court says Robinson didn't do anything. Now, why would the California legislature make this a crime? Probably this was just a way of making it easier for prosecutors to prove sale of drugs or possibly the dangerous conduct that comes from people who are under the influence of drugs. And the court says you can punish sales, you can punish the activities after you are under the influence of drugs, but you can't punish the status of addiction. This is unconstitutional under the Due Process Clause because the Due Process Clause requires a voluntary act, just as the common law did. A slightly later Supreme Court case limits the reach of Robinson. In Powell versus Texas, you've got a conviction of the defendant, Leroy Powell, for getting drunk or being found drunk in a public place. And the court here says that Robinson is distinguishable, that we can affirm this conviction because here there is a voluntary and preventable act involved, and that is going to or remaining in a public place while being drunk, unlike the pure status of being addicted to drugs or being an alcoholic. Here you've got some kind of action that the statute is targeting. The plurality says that if Leroy Powell couldn't be convicted of intoxication on these facts, then murderers might not be convicted of murder. Now, what did they mean by that? It's pretty clear that a lot of murderers are not mentally healthy people, perhaps people not truly in control of their actions. We've talked a little bit earlier about the reach of determinism and how it interacts with criminal law. Criminal law is built on an assumption of voluntary action, even though that may not line up exactly with the reality of psychology and what we know about the human brain. And the court says we have to accept that as our starting point here as well. So how do Robinson and Powell apply in the context of homeless people who might be punished for committing various acts like sleeping in public or eating in public, urinating in public? You could see it going either way, and in fact courts come out on both sides of this. Much of the time, these prosecutions are analogized to Powell, and you say, oh, we're just punishing conduct here. Sleeping in public or urinating in public or whatever the nuisance activity is. Other courts draw the analogy to Robinson, and they say, well, actually, once somebody is homeless, then they don't have a lot of choices about where they're going to relieve themselves. Or, for instance, there are occasional cases involving the requirement of sex offenders to register their homes, and if a homeless person fails to register, you can't convict them for failure to register. This invokes the same kind of involuntary action that concerned the court in Robinson. So in the end, some courts say you can't convict somebody of the crime of being hungry and poor, in the words of the famous Nina Simone song. Although we do generally require an act and a voluntary act in criminal law, sometimes we'll impute an act to the defendant. In specialized settings, we say that if a person has a duty to act, that's the important part, and then second is capable of acting but fails to act, then in that setting the person is treated as if they committed a criminal act, or put another way, we waive the voluntary act requirement. We're going to spend some time on this common law doctrine of omission liability. For now, I just want you to be aware of it categorically as an exception to the normal requirement, the one we just talked about, that the common law expects proof of a voluntary act. It's built deeply into the common law doctrine of criminal law, and it's now got constitutional status as a matter of due process when we say there are no status crimes. We'll talk more about the act requirement when we get together next. See you then. Lord, it sure is hot in the sun.